Well, let's continue to get some reaction on the ruling. We're joined on the line by Advocate Paul Hoffman. Good morning to you, Advocate. Thanks for your time this morning. Firstly, when we take a look at what the ConCourt has had to say this morning, particularly around the decision by the police minister to continue fighting this matter, and the fact that he had earlier conceded that the provisions under which the suspension was effected were in fact unconstitutional and illegal, one wonders whether it even needed to end up in the Constitutional Court to begin with.
Yes, that's a good question. Good morning, and good morning to your viewers as well. It's a question which Accountability Now tried to answer when the IPID legislation, which is the legislation that was used to appoint Robert McBride, found its way through Parliament and through the provincial legislature several years ago. At that time, the view in the corridors of power was that when the Constitution said an independent investigative unit to look into complaints against the police, it meant independent of the police, not independent of the executive branch of government. Well, that has been proved wrong by the finding of the Constitutional Court, and I think it was a unanimous judgment which was penned by Acting Justice Bosiello, who is one of the candidates for the vacancy in the Constitutional Court, which was read out by Judge Jafta about an hour ago.
Now, of course, the decision was set aside with costs also awarded, and of course the police minister has to pay for the litigation. One has to question the integrity of the kind of legal advice that the state is getting in the cases that it takes. I mean, we can make reference to Nkandla or even the Omar al-Bashir matter, which of course government fought tooth and nail but kept losing. Did the minister act on bad legal advice?
Yes, I think that the advice that the cabinet is receiving is very often the advice that it wants to hear, and rather than the constitutionally pure advice. And the difficulty is that the cabinet marches to the sound of a different drum. It does not march to the sound of the constitutional drum, and it's going to continue to be corrected by the Constitutional Court until it does. What really needs to be understood by everybody, including the cabinet, is that politicians in the new South Africa cannot do as they please. They are constrained by the principles and the values of the Constitution. And if they do things or pass laws which are inconsistent with the Constitution, then they run the risk of having those declared invalid, which is exactly what happened this morning. It's a great day for the rule of law and for the people of South Africa.
Advocate Hoffman, also just in terms of the independence of the I'm sorry. Also, just in terms of the independence of the IPID there, Advocate Hoffman, what does today's ruling then mean for them and the Hawks?
Well, as far as the IPID itself is concerned, it means that within 24 months, it is going to have independence from political interference and political influence from the cabinet, and that it is going to be accountable to our multi-party parliament rather than to the cabinet itself. What it means for the Hawks is more indirect. You'll recall that the Hawks were had their legislation amended by the Constitutional Court in November 2014, deleting parts of the legislation which it considered to be inconsistent with the constitutional requirement that there be effective anti-corruption machinery of state. So what we have now is a situation in which really what lies behind all of this is the desire of the cabinet to control what happens in the Hawks and IPID, and the desire of the Constitution to have independent bodies of that kind in order to see to it that corruption is dealt with properly. Our view at Accountability Now is that really what we need is a new Chapter 9 institution, an integrity commission that can operate between the work that the public does and the Auditor General does in a way that will bring corruption to its knees in South Africa instead of the levels of corruption which we are having to endure at the moment. The case against Robert McBride is about whether the rendition allegation against Dramot not. They were disregarded for many years until Dramot tried to start acting independently by cabinet as a pretext for getting rid of him. And that was also a mess, but eventually he couldn't take it anymore, and he resigned from the Hawks in exchange for a nice golden handshake. Now, in March this year, he has been charged. If it turns out that those charges are valid and that he is convicted, then Mr. McBride may have to answer for the changes that were made to the IPID investigative report about what went on there. If, however, Dramot is acquitted, then McBride is vindicated as the man who saw through the nonsense and was prepared to change a report that suggested that there was wrongdoing on the part of Dramot and Sibiya in relation to the Zimbabwean rendition. It's a very complicated story with wheels within wheels all over the show. But at the end of the day, the Constitution has asserted itself again in relation to this matter, and we have a situation in which we can rely on the Constitutional Court to uphold the Constitution and to assert the independence of bodies that are meant to be independent so that they can operate without fear, favor, or prejudice, and certainly without interference or influence from political parties.
All right, thank you so much for that analysis and your insights this morning. Advocate Paul Hoffman, then apologies, I got a bit distracted by the background.